Hey there, everybody. Welcome back. I'm Neil Tyra, and local attorney here in Rockville, Maryland. And today we're doing this Facebook Live event to discuss the topic of, do I really need a will? So after last week's Facebook Live event where we talked about the difference between probate and non-probate property, several people said to me, well, then, do I even really need a will? And it's a great question. And the answer is almost always, in my opinion, yes. Now, you can plan properly such that a will is less important, but it's really the odd situation where you can get away without having a will. So in my opinion, you're better off having a will in almost all circumstances. And the reason is just because it gives you the control to have things handled the way you want them to be handled, as opposed to letting somebody else decide. So then the question arose from a couple of people, well, I don't have enough stuff. You know, I'm not rich. I don't have anything to really worry about. Why can't I just let the government decide? And that may be a proper question, but in many cases, it may not be. And one of the most frequently cited situations, or one that I like to point to, is particularly if you have children. So my question would be, well, if you got hit by a bus, who would raise those children of yours? And oftentimes I get, well, I don't want his family to raise it, or I don't want her family to raise the children. And I would say to that, well, unless you have a guardian specified in your will ahead of time, then either grandparent, for instance, has an equal right to petition the court to be allowed to raise that child. So that's one thing to think about. So I thought what we do is talk about, what does a will cover? What does it have that's important? And that'll take up most of our time, and we'll see where we go from there. So the most obvious reason to have a will is to give stuff away. It's called bequests. So you can specify in your will specific items, tangible property, or specific amounts of money, or specific types of value that you want to give to a particular person. So, you know, to my loving husband, I give $1 million, or specific gifts such as my mother's diamond ring goes to my eldest daughter, or something along those lines. I usually like to think of that as my big treasure list, the things that are really important to me personally that I would like to see go to somebody in particular. So that's the first part of a will, the specific bequests or tangible property issues. The rest is just that, everything else. And there's a number of different ways to structure it logically. One way is to create an addendum to the will, or a memorandum to the will, that lists all the other tangible, assets. So be things like the refrigerator. Well, not the refrigerator. Who's going to give away a refrigerator? How about the dining room set that's been in the family for 50 years, or a specific TV, or a car? You can actually put those in a memorandum that's attached to the will, so that you can change that list at any time. You can add to it, take away from it, change who you want the item to go to, without having to redo the will itself. So the will kind of points to the addendum. So we call that a personal property list. So that hey, Mike, let's see you. Mike Gottlieb, my friend from high school. We'll get to that in a second. Your question. So that's one thing you can do, and then as I said, everything else is what we call the residuary estate. And in the residuary estate, it means I want everything else that's not specifically identified in the specific requests. I want everything else to go as follows: to my children, or to this class of individuals, to my cousins, or to my brothers and sisters. You can do it by class, or you can do it by bloodline. And it brings up one of the most misunderstood phrases or terms, A lot of times we'll say to my children per stirpes, P-E-R, new word stirpes, S-T-I-R-P-E-S, per stirpes. And what does that mean? So per stirpes means that let's say you have 3 children and you want to give away your residuary estate, everything that you didn't give away specifically, you want to give to your 3 children per stirpes. Well, if one predeceases you, if one dies before you do, then what that means is their share would go to their children in equal amount. So if you had 3 children and they were all inheriting from you, but one passed away before you did, then that person had 2 children, then those 2 grandchildren of yours would inherit the deceased child's share. And that's all that per stirpes means. But it confuses a lot of people. It's always on the bar exam when you graduate from law school what that means. So that's an interesting part. Then the last logical section of a will is what's called the remote contingency beneficiaries. So it basically says, what happens if everything that I had planned for, if everybody's gone, everybody predeceases me, there's a zombie apocalypse or something, and everybody's gone, and all my family that I wanted to give things to, they're no longer around or with us. So a remote contingency says, well, in that case, give everything to this individual or class of individuals, or oftentimes a charity. So people will pick a charitable entity or maybe a church, and they say if all things fail, then give it all to the church or give it all to this charitable foundation, or follow the laws of intestacy. So give it to whomever would have gotten my estate had I died without any beneficiary, without a will. So if I had died intestate, that's another way of framing the remote contingency. So those are the 3 basic logical functions of a will. But I mentioned also specification of a guardian. So in your will, you should specify who's going to raise your children if you're not there to do so yourself. And so for some of my younger clients, younger families, that's the most important function of the will, because they don't have a lot of stuff yet. They want to build their estate plan in a way that provides for eventualities, but until that time, the most important question that they have is who's going to raise their children if they're no longer with us. So having a guardian named in your will is extremely important. And the other major decision you have to make is who's going to be the executor, who's going to make sure that your will is followed, who's going to file it with the court and do all the things necessary to effectuate the steps that you have laid out in your will. And that's called your executor. So what you need to do is name an executor, and we usually like to also name a successor executor or executress. In the event that the executor is not available, maybe they predecease you or they've moved, you can't find them, you need to have somebody to take over that role when the time comes. There's one other thing that we include in our wills that is somewhat unusual these days, or maybe hasn't been addressed in the past, but we also create something called a special needs or supplementary needs trust, a contingency trust. And in this case, Michael, this is not exactly your question, but it's on point to a degree. What happens if a beneficiary that you've named, and maybe they're not even alive yet, maybe they're a to-be-born niece or nephew, what happens if at the time of their inheritance, they are a special needs individual and are getting government funded or means tested benefits, such as Social Security and what have you from the government? You don't want the inheritance, which may not be enough to provide for them on a lifetime basis. You wouldn't want that inheritance to prevent them from getting their government benefits. So in that case, you create what's called a springing supplemental or special needs trust. It only comes into being if those conditions are met. the beneficiary is special needs, and they are receiving means tested government benefits, in which case a trust is created, and you specify the terms of the trust in the will and who's going to be the executor or the trustee of the trust in the will. So that's the major functions of a will. Do you need one? I say almost in all cases, yes, unless you're, single or without children, and you've structured your estate such that everything is done through a beneficiary statement or through jointly owned property, as we discussed last week, the difference between probate and non-probate property. Just to finish up here, my friend Michael Gottlieb, way back from the downtown Booyah High School days, asked the question, do I recommend trust? And actually, I'm going to talk about that next week, Mike. But let me just say here, yes, I recommend them in certain cases. And the most obvious case, at least in the state of Maryland, the most obvious case for the need of doing something like a revocable living trust is if you own property in multiple states, in which case you would create a revocable living trust. You'd be the trustee for that trust. You'd move the property into that trust, retitle it in the name of that trust, so that when the time came, your family would only have to probate one will, one estate, as opposed to doing one in every state in which you owned property. So we're going to talk about that a little bit more next week, but hopefully that'll give you a sense of what we're talking about. So I see Jack Stevenson, another old high school friend, joined in, and Judge Algio, welcome. Forever indebted to you and your family for all that you've done to me to help me get to this point in my legal career. And with that, I'll say adios, and we'll see you all next time. A week from today, we'll do another one of these, okay? Thanks.